Mosey
We
on.
have 3 items on regular rules and 2 of those are nominations, so we wanted to table it to
To the rules.
well, move it to the regular rules today. We'll have to amend and put it on there because that agenda's already posted.
Okay, yeah, let's see what we get.
Oh, you know, I have a piece of cake. Very good. Here.
2, 3, 4, 5. Need 4 more.
There's Thornton. Garvin. Snell.
Denise. Let's at least establish a quorum, guys, and you guys go back in there and eat. If Janice and I can fast, you guys can fast.
Counselor Anglin and Garvin are coming.
3, 2,
Yeah, Counselor Hargis, would you bless the meeting?
Heavenly Father, we thank you for this day, for the beautiful weather you have blessed us with. We ask you to bless this meeting and just to guide and direct our decisions. In Jesus' name I pray. Amen.
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 Okay, Shelley, roll call.
yes, sir. Joe Bird.
Ani?
Randy Hargis.
Present.
Bill England.
Here.
Keith Austin.
Here.
Jack Baker.
Here.
Harley Buzzard. Sean Crittenden. Don Garvin.
Honey.
Wanda Hatfield. Rex Jordan.
Here.
Dick Lay.
Here.
Curtis Snell.
Here.
Janice Taylor.
Here.
David Thornton. Victoria Vasquez.
Ani.
David Walkenstick. Brian Warner. We do have a quorum.
Okay, thank you, Shelley. Apologize to the staff that were here. We were celebrating the return of the bike riders, and that just went a little bit over time, but we are here, and this is a special meeting, so at this time, I'm going to turn it over to Attorney General's office here.
Thank you, Chrissy Nemo, and for Todd today. Before I get started, and I'm going to go through this really quickly just to do a little bit of overview, but I did want to inform the council. Part of the reason that we started working on this was because of the Dollar General case, and we wanted to update our civil code. There was a decision in the Dollar General case this morning that wasn't really a decision. It was the Supreme Court tied 4-4, which means they didn't overturn the Fifth Circuit opinion, which stands, and the tribe won there. Just really briefly, Dollar General had a store on tribal land. They had leased from the tribe. It was on trust land. They did basically an internship program with a young man who was sexually assaulted by an employee of Dollar General. And the family of that young man in tribal court sued Dollar General for damages. And Dollar General argued that the tribal court did not have jurisdiction because they hadn't entered a consensual relationship that would have covered that type of tort case against them. And it was a big case for Indian Country. The good news is, again, that the Fifth Circuit decision, which was very good, stands. The bad news is this kind of case is going to go back before the Supreme Court. What will happen is another federal court will have a decision that is different, or there will be a different case, and the court will take it up again when they are back to full staffed, and it will be decided. So we got a little bit of a reprieve, but one of the things that tribes have been encouraged to do in wake of this suit is to really look at their codes in tribal court, their due process standards, and In this case, the state of Oklahoma Attorney General, supported by several other states, filed an amicus brief supporting Dollar General, arguing that to allow tribes to have civil jurisdiction over non-Indians would create this mess in courts. And we have had a civil code in the modern Cherokee Nation. It was pretty sparse. And what this was an effort to do is to put some of these areas of tort law that kind of aren't common law. So the common law types are negligence. You get in a car wreck with someone, you've harmed them, you've injured their property, you go to court and say this was their fault, they owe me this much money, the court decides. Some of these bigger deceptive practices and defective products and those types of things, we currently have a case in tribal court, so I can't talk about the details of it, but we filed a case against a drug manufacturer for a product that was provided to our citizens that is alleged to have harmed them. And these are the types of cases that, one of their arguments on appeal was that we don't have this codified in our law. And the answer is it's still a common law cause of action. And what this law does is reserves any common law types of action. So if in the history and tradition of Cherokee Nation there would have been a way to go after someone who committed a wrong, those types of remedies and cases still exist. But this was an effort on some of these what can be very technical and very large cases to lay out the law very clearly. So if an individual citizen or the Cherokee Nation on behalf of its citizens files a suit in the future, they don't have this argument that, well, we didn't know what the law was and we didn't know how to file papers or how much time we had to respond or what constituted jurisdiction of the tribe. So this was an effort, our staff worked on it as well as with some other attorneys to really get a comprehensive civil code. And if you'll allow me, I'm going to try to do this in about 5 minutes and just kind of go through each heading and describe what those parts are and what they mean, and then I'll be able to answer any questions if you have them. The very first, after the jurisdiction, that says we can exercise jurisdiction on any basis consistent with our Constitution. Our Constitution defines our jurisdiction as our 14-county territorial jurisdiction. Law to be applied makes it very clear that this law doesn't repeal any common law actions that someone may already have. The Federal Rules of Civil Procedure and Evidence, we already followed those. One of those were by statute, and another of those were by Supreme Court order of the Cherokee Nation. And those are the rules that deal with how you have to serve a person, how long you have to answer a complaint, on what grounds you can file motions to dismiss. And those rules in and of itself, each of those books is about this thick. So in lieu of asking the council to adopt rules of Cherokee procedure and rules of Cherokee evidence, this says that we're going to follow the federal rules that they follow in federal court. Unless the council changes anything, or the court, because sometimes when it comes to service and filing, that type of thing, the court can make rules. So if there's not a conflicting Cherokee Nation law, we will simply apply the rules of several federal civil procedure and federal evidence in any cases in Cherokee Nation courts. And that's been the practice already in Cherokee courts. What you will see on the next page, on page 3, are the deletions. Page 4, limitations of actions, also called statute of limitations. And these are very common. They just say, if it's this type of case, you have this long to file it, because you can't indefinitely file cases. What is really important about this is it says that there's not a statute of limitations when the Cherokee Nation is the plaintiff. So when the tribe is filing an action under this, they're not bound by the same statutes that a individual would be on filing that. And the next page, on page 5, parents patriae. This is a section that specifically says, although we believe that we already had the right to do this, specifically says that the nation can bring a suit on behalf of its citizens for injuries that were caused by its citizens. And it lays out that they're still able to recover as individuals, but the tribe may have additional expenses to recover than the individual. For example, the case we have now, or in the event that, a hypothetical, we're doing hip replacements for our citizens at Hastings, and those end up being defective. That individual is going to have claims for damages because they were injured by that. But we did the initial surgery. We have to go back in and do the second surgery to fix it. We're expending time and resources that may not be recoverable by that individual, but would be recoverable by the nation as a whole, because they had to kind of fix the problem that was caused by someone manufacturing a defective hip replacement. That's one I use because you see those commercials on television all the time, that if you've had this medical procedure, call this number because there's a lawsuit. So this section just talks about what Cherokee Nation, in representing its citizens as a whole, what kind of actions that they can take. I'm going to skip to, and we'll go back if anyone has any questions about these. Page 7, wrongful death. It says if you cause a person's death, these are the damages that you can be responsible to for that person. And that's an example of one that very well is and would remain a common law action. If your actions cause the death of a person, for as long as there have been courts, you have been able to go in and say, the surviving family, I'm owed this because you took this person away from me. You took our source of income, you took companionship. And what this does is specifically lay out what can be recovered in those cases and who's responsible. Page 8, joint tortfeasors. These are very legal words, but this is also very common. So this says if two people cause the death of a person and you're suing them, if they're found to be responsible, either one of them are responsible for the entire damage. So you have maybe a driver of a company truck, and then you have the actual company itself. The person who's driving the truck may have been the one that caused the accident, but they're probably not going to have very much money to pay off if there's some type of damages awarded against them. But you may be able to go after the owner of the company because they're responsible as well, and you can get the whole amount from any party. And that just keeps people who receive judgments in cases from being prohibited from getting the money that's owed to them, because the person who may have directly caused an accident or directly did something wrong may not have the pockets to pay that, whereas a business or a larger company may. Page 9 lays out the requirements for class action lawsuits. The difference between a class action and the one that I talked about earlier that would be brought specifically by Cherokee Nation on behalf of its citizens, the class action are the individuals who actually suffer some type of wrong, and one or several of them are chosen to represent the entire class. And I don't know if any of you have ever gotten those notices. I got a check this week from a class action lawsuit from some shoes that I bought, and they were the ones that go around your toes. And the court found that they had falsely advertised those shoes, and I got a notice saying, hey, if you've ever bought these shoes, sign this piece of paper, send it in. And they sent me a $20 check because I was part of the class. And those are really common. You'll see a lot of cell phone ones and that type of thing. But this just lays out the requirements to certify a class, who the representatives can be. And this is one that, although very much probably a common law type, they're very, very complicated because you get lots of people involved, lots of claims involved, and you need rules on if you don't join this class and you're excluded. If you don't want to be part of the class and you want to file your own lawsuit, there's got to be a way to take you out of the class. So these are the rules that set out how you do those. I'm going to skip to page 11. This is simply the appeal process, and talks about if you lose and you're appealing and there's a money judgment, you may have to file a bond. That's the very, very common. On to page 12, unfair and deceptive practices. This is a pretty long provision, but this is one that's really important, and it lays out that if either individuals or companies approach Cherokee Nation citizens, whether they are selling goods to them, providing services, soliciting something from them, that they can't do that unfairly. And this is a section that is really important when we think about some of our vulnerable populations, our elderly, some of those folks. One of the things that you'll see in here and this whole section is pretty much the rest of this, but one that just worth mentioning, there's several of them, and if you have specific questions, an example is charging or receiving an unreasonable fee to help someone receive social services. So these are the types of people that will go to elderly populations or underprivileged populations and say, hey, there's this benefit that the Cherokee Nation provides. Say it's clothing vouchers or it's rental assistance. And if you pay me this much money, I can help you get that. Well, you shouldn't have to pay anyone money to help you get that because that's a service that you're entitled to as long as you meet the requirements as a citizen. But there are people out there that do that to take advantage of people. And that's one example of several in here, but those are the types of things that we're talking about. So not only could that individual go after that person, but Cherokee Nation, on behalf of its citizens, could go after a person or a group of people who are unfairly targeting citizens who may not have the sophistication to know that they can go hire a lawyer and go after this person. And so these are really important. These are things that are codified at the state level in most states. And again, one of the reasons that I know this seems very broad and in-depth, but these are very complicated cases when they go to court. So part of wanting to put this in the law is that it's very clear on what the rules are, what the requirements are, especially in the event that we're going after non-Indian people, individuals, or companies that come in and do business with us. So they don't have the argument that they didn't know what the law was in Cherokee Nation. We publish all of our laws online. So it's presumed that when you're doing business with the Cherokee Nation, you are aware of their laws, especially when, like ours, they're publicly available. So no one's going to have that defense, well, we didn't know that we couldn't do this at Cherokee Nation. The false advertising, which is part of this, is kind of along the same lines. Page 19, just as an example, if you're going to someone's home and soliciting the sale of goods or services, there are some things that in here you have to do. You have to identify yourself, let them know what organization you're with. A lot of this, too, is going to give protection where people might claim an affiliation to the Cherokee Nation that's not there because they're selling a product to Cherokee citizens, or they've put a seal of the Cherokee Nation on something that they're trying to sell that maybe isn't what it's purported to be. So these are the types of things that really do happen. I mean, you all probably get some of these calls from your constituents. We definitely get them from the public. And this code is designed to give us as a nation, and specifically the AG's office, the ability to go after these people who may be taking advantage of some of our citizens. The remedies section, page 21, just specifically talks about what damages are available, how those are calculated, which is, again, something that if it's not written in the code, it's kind of up to the judge or up to the jury to determine what the punishment is. And by putting these things in the code, someone doesn't have the argument that they weren't aware of what they might have to pay if they were found to have violated some of these rules. It gives us the ability to seek money, injunctions, recover property, seek punitive damages, which was one of the issues in the Dollar General case because, it's hard to put a number on the monetary damages of a child being assaulted. There's some medical expenses, maybe some long-term therapy expenses, but in that case, the money that the family could have recovered, if not for punitive damages, would have been very low. And punitive damages are designed to change behavior and make the people who commit wrongs not do that again. So in that case, the punitive damages were telling Dollar General, you don't get to come into Indian country and put sex offenders in work in your stores that are then going to come after our children. And it's a message to them that you need to change your behavior. Maybe you need to do background checks on your employees. So that's why we want to be able to go after punitive damages. That is, final is just interest on judgments, and if you get a judgment and someone doesn't pay it for so many years, you earn interest on that judgment because you should get the money right then, and if you're not, interest applies to it. That's a common state, federal, and tribal court remedy for money. So that is wasn't quite 5 minutes, I think it was about 10, but that's a brief overview, and I will entertain any questions that anyone may have.
You did good.
Thank you.
You know, back to, just quick on the Dollar General. Dollar General did sign off and consent to, if there's any arbitration disagreements, they go back to tribal courts, correct?
And they did that with the lease with the tribe. So they argued the tribe could sue us in tribal court if we violated our lease or if we did something. But this was kind of a third party because it was a family of the child. And they said us signing a contract with the tribe to lease property from them and agree to dispute that in tribal court doesn't give this family the right to go after us. And what the court said is it's not necessarily that, although that was one of the factors, it's not necessarily because you signed a contract with the tribe, it's because you're on tribal property, you were receiving a benefit, this child was working in your store and providing service, and you agreed to this mutual relationship with the tribe, with the tribal citizens, with the tribal land, and of course the tribe has jurisdiction over you.
Sure. Okay, thank you. Anybody, questions? Yes, Council?
I would also say that there's a long time history of case law that allows tribes to have civil jurisdiction over non-natives. It's just not criminal jurisdiction over. And I think that you all are familiar with the background of what instigated the Dollar General and Mississippi Choctaw case. I've talked to several of you. If you have any questions, we can visit afterwards. But also, Speaker Byrd and Deputy Speaker Vasquez and me and A.G. Hembry were all at the oral arguments at the Dollar General case at the Supreme Court in December of 2015. We're still waiting on that final decision. And the final...
It came
It came down.
Oh, it
Today.
did?
Yes.
When?
It was a 4-4, so it's, the Fifth Circuit's affirmed.
And in favor of the tribe?
Yes, yes.
Oh, that's a good, I didn't hear that. I didn't know that, but that's good news because that, a negative decision would have really impacted tribal courts and their jurisdiction in civil cases. So I'm glad to hear that. That's great.
Okay, anybody else? Yes, Councilor Baker.
Yes. Thank you, Mr. Speaker. On page 2,
Yes.
under the force of the Cherokee common law, and also paragraph 3 and paragraph 4, as the Cherokee common law consisted of the traditional customs and uses of the Cherokee people since time immemorial. Do you have any examples of what that could be?
So, to my knowledge, we don't have any published cases, modern day published cases incorporating Cherokee traditional law. We know, the fun example is not fun, but we had blood law at one point and it was repealed, so we're obviously not going to have that anymore. But there are situations, and some of the areas where you think about this are things like some of our juvenile healing to wellness courses and custody cases and that type of thing, where the judges very well may rely on traditions within the Cherokee Nation. For example, extended family, so maybe grandparent visitation. Although that's codified in our code, it is something that we would all know as Cherokees, that if you take a child, and place him with one family member, the other family should still have contact with them. And I think you're going to see it more so probably in juvenile cases. Our criminal code is very specific and has to be, and the civil code is, if this is passed, is going to be very specific. But the reason that's in there is if there is some argument that the tribe wants to make or that an individual citizen wants to make, that within Cherokee tradition and culture this is a way that this would be dealt with, that they're still allowed to make those arguments to the court, and the court's still allowed to consider them, even though we may not have them in our code anymore.
Because I do understand the child custody cases and all that. Good.
But that is specifically reserving. It's not identifying them because, and different people may say that there are different ways it should turn if you follow custom. But What it is, it's reserving them and saying that you still have the right to come in and argue to the court that they should do something a certain way based on the traditions of the Cherokee Nation.
I just want to be sure that we don't go back to the time when the women owned all the property and,
Why not?
That's where we're going.
That's what it means.
okay, thank you, Mr. Speaker.
But yes, Council Garvin. Yeah.
As attorney out on the street, I know probably the tribal attorneys will like this, but the others maybe won't. Is that a good assumption?
I don't know, they might, because they might want to come file cases in our court against,
Make more money?
right.
So
I don't think there's going to be any
is it
opposition to this.
complicated or make it simpler?
It's a complicated law, I think, when you look at it, just because it has a lot of legal language. But I think attorneys will like it because they will say, we don't have to make any guesses about whether or not we can take these kinds of cases in Cherokee Nation because it's now laid out in the law.
Which attorneys will like it best, the pro or the con?
The pro or con of what?
The case they're trying to look at.
Oh, the pro.
Yeah, it depends.
The pro. And for example, the Dollar General case, the support for the tribe. And this is something that we're hearing. You go to NCAI and they talk about this case and they're encouraging tribes. This is a good time to take a look at your codes, and this is a good time to think about updating them, especially now that we got a little bit of reprieve because we didn't lose the Dollar General case. It's probably going to go, a similar case is going to go up again, but we have the opportunity to now, as tribes, to get our written law in order, so when this comes up again before the Supreme Court, one of the arguments that the Oklahoma Attorney General made was that a lot of tribes don't have formal court systems and they don't have written laws, and although we always have, this is just an opportunity for ours to be even clearer and better, and that there's no doubt that if you're doing business with the Cherokee Nation, you know what the expectations of your behavior are, because you can go to the Tribal Council website and look at the law that's been passed and understand exactly how you have to act when you're doing business with Cherokee Nation.
Okay, thank you, Mr. Speaker.
Good. Yes.
There's one other case, issue coming up, Chrissy, it's that fast case issue. There's a meeting today down at the Choctaw Casino down in Durant with the whole group. It's called Fast Case Group that will help tribes. Because I think there is, it was discussed at the sovereignty symposium, and the Supreme Court in Oklahoma now would like for all the tribes to be able to post their decisions. And so that may be something that the council might want to address at some time. Maybe, I don't know if the Supreme Court our Supreme Court is talking about that, but Oklahoma Supreme Court now is asking for decisions and orders issued by tribal courts. Now they want that to be, and that's maybe something that would be a benefit for other tribal courts. So somebody ruled that way, and it could be a basic, like we use in other oral arguments. So I wanted to let you know that that is coming up, and we'll see if, I'll get with you and the AG to see if we can talk to the Supreme Court to see what they are thinking about on that.
Counselor Lay. You have a question?
Excuse me? Yes,
Good.
Used to be a waitress.
Excuse me. This seems like, it's a big, broad law. Are we expected to vote on this today?
That is up
I'd
to
prefer
you.
not to. Have y'all vetted this with other nations, with other tribes? Are they doing a lot of the same things, or are we all together, or are we just doing 42 different?
I think that there are tribes that have codes probably similar to this already adopted. I think there are some that have taken steps that are, somewhat less than this. And I do think that you will see, I think you will hear whatever the next NCAI, I keep saying, I think that's an example, because we do now know what the decision in Dollar General was, which was no decision. But they will be encouraging tribes to do what they can. We don't think that our courts are inferior to state or federal courts. In fact, we think they're better than. but they are looked at from the outside world as less than. And a lot of times that's because they don't look like other courts. Ours do. Our courts very much look like we have our law online. We publish our opinions. We have a district court and an appellate court. We handle all types of cases there. So ours are very similar to state and federal courts. But what tribes are going to be being told from, kind of tribal leadership is make your courts not look like state and federal courts, because we don't want them to, but make them as accessible. If you have a written law, put it out there where people can find it, so they're not accusing tribes of trying to hide something or trying to be unfair against outsiders. And I definitely think that you will see, especially as a result of some of the cases, because some tribes have been very successful in bringing these types of actions in their tribal courts. And as other tribes see that, like I said, we have a case pending in tribal court now where we have sued a drug manufacturer. If we ultimately prevail on that, you are going to see other tribes wanting to bring those same types of suits in their tribal courts for the benefit of their citizens and their tribes. So I think we may be on the leading edge of this, but I think it's something that other tribes are going to do and going to support and going to follow.
I'm sure you've looked over this thoroughly, but I mean, is there a poison pill in here for us somewhere that you have seen? Because sometimes, and we've done it here. We've made laws that we look back later and said, whoops, we need to stop and go back and rectify that. And so I want to make sure if we do this, that you guys have run your traps.
I can tell you our office spent a lot of time on this, and
We spent a lot of time on other laws we had to go back and redo.
it looks
That's my point.
it looks very complicated, but this is a win-win. I mean, this law is allowing Cherokee citizens and the Cherokee Nation on behalf of its citizen to bring suits that some may have argued in the past that they weren't allowed to bring. We would have argued that they were. There's nothing in here that waives the sovereign immunity of the nation, so none of these suits specifically say you can sue the nation for this.
I was looking for a word term in there.
Yeah.
Will we be able to, there are companies who ask us to waive sovereign immunity for a lot of things. Will this replace that?
No, they will.
Because I don't like waiving
understand.
sovereign immunity is kind of just rubs me the wrong way. We do it a lot. Of course, we do a lot of business that other tribes don't do.
And part of this may actually help that argument, because oftentimes when we're asked to waive sovereign immunity, it's because they want us to agree to go to Oklahoma or federal court if there's a dispute, if there's a lawsuit. So let's say we are doing a contract with some big manufacturing company and they want us to agree to the jurisdiction of the state of Oklahoma. We may be able to point to this and say, we have a defective products law here. We don't need to go to Oklahoma because we have a law on the books that you can look at and read. And in the event that there's some type of dispute, we can go to tribal court because we now have a written law that covers the issue that you may be afraid of coming up later. So in that sense, I mean, that's a very narrow type of area, but it may actually help us in the long run. The more robust our code is, the more those outside of Indian country are going to be willing to submit to the jurisdiction of the tribal court when they see that we kind of look like other courts. They can go read our law. They can read case decisions interpreting our law. And the more that we do that, the less likely they are going to be to say, we don't know about tribal court. It's all weird and strange and we don't want to be there. And if we continue to develop our law in a written form that's available to outsiders, they're going to be more willing to submit to the jurisdiction of our courts because they know what the rules are before they come in.
It's going to hurt any of our citizens rather than help, or will it help or hurt?
Counselor Lay, I don't think that there is anything in here that is harmful in any way. I mean, the only citizens that it would hurt is if we have a citizen who's doing some of these things that we're trying to prevent, a bad actor.
I'm not referring to
Any of our citizens who that would seek their own actions or that we would seek actions on their behalf under this is going to do nothing but help them. And it gives them an additional place to seek a remedy. One of the big issues in the Dollar General case, and one of the arguments that the other side made, was they wanted it to be in state or federal court. But there's a possibility that state or federal court couldn't have heard that case because it happened on Indian country, on trust land, and the state's jurisdiction is somewhat limited, the federal jurisdiction is somewhat limited, and we know up until VAWA was passed on the criminal side, there were Indian women who were left without remedies, that their non-Indian offenders couldn't be prosecuted criminally. And you occasionally have the same situation with civil cases, that there might, if tribal court's not available to them, they might not have a remedy somewhere else. And this very well could be a situation where it allows a tribal citizen to bring a suit and seek some type of recovery that they wouldn't otherwise have been able to do. But there's not, this is, and I know it's very different than a lot of the laws that you all pass, because it's very complicated. It has a lot of legal words in it, but this is something that's good for the tribe, it's good for our citizens individually, and it's good for us as a whole.
Thank you.
I'm going to make a comment because we're getting ready to get into rules. It was my fault that we were late on this one here. So what I heard at the Supreme Court hearing in the Dollar General case was that, you know, one of the person on the bench kept talking about the quality and the competence of our tribal courts. Not the Cherokee Nation court, but just kind of a stereotype
General
comment there. What we're actually doing here is getting ahead of the game. It would be nice if there was another tribe out there taking the lead, but a lot of times, believe it or not, we are the lead. When we're talking about education, we're talking about health care, we're talking about, you know, these codes. It'd be neat if we could go look for another tribe and say, would you guys, someone else take the lead? There's 567 tribes out there, but we are the lead. And so we can do one or two things. We can continue this, and we'll have to amend the agenda in rules if the council committee wants to continue, or if there's something you want us to do this month, or can it wait till the month of July?
I will say, it was presented last month, and we set this meeting specially, and I know we were running behind because of removal, to answer any questions. That's obviously at the council's will. If there are additional questions, we're willing to come back.
We can move this into new business in the rules. I don't see a very long agenda in the rules. We just move it into the next committee, council, if that's okay. And if there's any additional questions, we can do it there, or we can table or move it to July, whatever the wishes is of the committee.
I
Yes,
just have a statement. I think it'd be very good if we went ahead and addressed it today.
okay.
Because the July meeting is an all-day, every meeting on one day, and we don't want to add to that.
I agree.
That's just my opinion.
Okay, anybody else? Okay,
I will be here for regular rules.
we're getting ready to start the rules. Why don't we take a, I didn't see that much on that agenda. I need 10 minutes just to, you haven't even been here, so, so anyway, Councilor Baker.
I make a motion that we table this to our regular rules committee meeting starting at.
Second that.
Okay, got a motion second to move this to regular rules. Okay, we will take a 10-minute break. Good job, Councilor
We
Watson.
need to vote on that.
Yeah.